So thank you all for joining us for our Small Business Solutions Series workshop. I'm very excited today to have Mike McClory join us today to talk about one of the things that I know I've been hearing a lot of questions about, a lot of ambiguity as we begin to open up again, and as businesses begin to bring employees back to their workplace. What does that look like? Lots of questions on both sides, from an employer perspective as well as an employee. I think it's really important to have at least some good advice around best practices and what you should and shouldn't be doing or thinking about. So I'm going to resume the share here, Mike, and this will have your presentation on it. And I'm happy to advance the slides. Just tell me in move slide or move forward and I'll do it.
Well, there isn't a whole lot to the slide set. I mean, there's basically slide number 2, which has the agenda. So, I mean, we could always put that up.
Got it. There we go. I did it. Everybody can see that okay? All right, Mike, I'm going to turn it over to you.
All right. Well, good morning, everybody. My name is Mike McClory. I'm an attorney in Portland with a firm called Cable Huston. And it is hard to believe that I've been doing employment law on behalf of management for a little bit over 30 years. It seemed like only yesterday I was struggling through finals in law school. But it has been, in addition to 30 years of practice, it has been an education over the last 2 months, getting up to speed with COVID-19. What does it mean as employers sort of wind down their active businesses, and now what does it mean as they actively try to get back to work? It has been a challenge so far for employers, and I think that will continue. So what I'd like to do today is, number one, if you have questions, feel free to ask them, because I can either answer or we can talk about the issues. But two, I want to go through some of the types of things that employers should be thinking about as they get ready to move into a more active phase of activity, and also some things that employers may be may come across, questions they may get from employees who are returning or wondering about returning. So I thought I'd first start out by giving a short update on where we stand in the state of Oregon. Governor Brown issued, she has issued both an emergency order, which gives her certain emergency powers to, do more with testing, move medical personnel around, that kind of thing. But then she's more particularly to businesses and schools, she's issued a stay home, stay safe executive order. And that was issued in March and is currently in effect and will stay in effect until it's rescinded. There is not an expiration date for it. Last week, the governor issued some preliminary information about the phasing in of businesses again, and most of that has to do with the location, meaning the county, and with testing and with contact tracing. And my understanding is that for some rural counties that haven't had much in the way of positive tests for COVID-19, they may be able to start opening as soon as May 15. Other counties, such as Multnomah, Clackamas, Washington, where there's been much heavier activity with COVID, that may take a little bit longer. Nonetheless, employers are thinking about reopening or re-engaging in their business. And so with that in mind, there are some things that we should talk about. I'm going to deviate just a little bit from the order on my agenda. And so what I want to talk about next is the Families First Coronavirus Relief Act, the FFCRA, that created emergency paid sick leave, emergency FMLA expansion. It has a provision in there for enhanced federal unemployment benefits. And the reason I want to talk about that, a lot of folks were interested in this back, at the end of March, beginning of April, when it was passed, and as they were trying to decide whether to furlough employees or keep going. And the reason this will continue to be important is because these provisions will stay in effect through the end of the year. And, something could happen after that, but at least for now, they're in effect through the end of the year. So what does that mean? So with the emergency paid sick leave, that gives an employee who qualifies up to 80 hours of paid sick leave, paid at various rates depending on the reason for the employee taking the sick leave. And there are 6 bases. I won't go through all of them, but essentially, if an employee is sick with, either diagnosed with COVID or has COVID-like symptoms, has been ordered to quarantine, is taking care of somebody who is sick or has been ordered to quarantine, has a child whose school or daycare has been closed and is no longer available. In those circumstances, that employee likely would be eligible for up to 80 hours of paid sick leave, and this will continue even after businesses reopen. I've talked to a number of employers over the past couple of days who were under the impression that maybe this wouldn't continue to be a thing, but it will be. And the same is true with respect to emergency FMLA expansion. Now, I don't know whether you all are large enough to be covered by the FMLA or OFLA, but to the extent that you are, this FMLA expansion allows additional bases for taking up to 12 weeks of family leave, and under this act, the leave is partially paid. So those are 2 of the emergency laws that will continue to be in effect. Now, also, as employers begin to reopen, they will still be subject to all the other employment laws that were in effect before all of this ramped up. So the ADA and parallel Oregon law, FMLA, OFLA, paid sick leave. So those were in effect before the pandemic. They're still going to be in effect. And so when employers recall folks from furlough or otherwise open up, they're still going to need to comply with those laws. So with all of that said, I thought the best way maybe to get into this idea of, how do we reopen might be with a scenario. So I came up with a scenario, and our company is called Hard Knocks. It's a door knocker sales and repair business. 20 employees, an owner named Stu. It's a diverse workforce, 10 men, 10 women. It's majority white, but there are 9 minority employees. And so the governor issued the Stay Home, Stay Safe executive order. And in the age of social distancing, door knockers were considered non-essential because we're not visiting and going with other folks. So Stu furloughed his entire workforce and has been closed, for a month and a half, let's say. No promises were made to the employees who furloughed about. Did I lose you?
No, not here.
Oh, okay.
No, I think you're good, Mike.
Okay. Well, my screen went blank, so I got a little concerned. So anyway, no promises were made to the 20 employees who were furloughed about whether they'd return or not. But now that things are looking a little better, the business is looking to reopen in phases. Hard Knocks wants to get back in the business of getting front doors equipped with proper knockers. So phase 1 would be to bring back 8 employees from furlough. So let's talk about, what do I have here? I have 6 issues. Let's talk about these 6 issues related to bringing employees back. First off, if we're going to bring 8 employees back, one question, who do you bring back? The answer is you can bring back who you need, obviously, but bear in mind that discrimination laws continue to apply. So discrimination based on race, gender, age, all of those kinds of things. So when you're thinking about bringing back a portion of a workforce, before thinking about the names, John, Sue, Kathy, whoever it is that you want to bring back, think more about the functions that you need. Think more about what it is you're hoping to accomplish, in this case, with the 8 employees. Because what I think it is important to do is to identify your legitimate non-discriminatory criteria for recall. So if we're going to recall 8 people out of 20, we want to know, before we start looking at the names, what is it we're doing? Are we recalling based on seniority? Are we recalling based on the need to have folks who meet certain skill sets? Are we recalling folks who are trained to do more than one position? Whatever the basis is, you want to make sure that you know that before you start listing your 8 employees to return. What you don't want to end up with is having somebody, an employee who has not been recalled from furlough, who can say, or at least can allege, that I was not selected to be recalled because of my race, my gender, my age, my religion, my disability, whatever it might be. You want to be able to be in position to say, no, these are the criteria that we used. So that's an overall idea on, how do you choose who to recall. Now let's talk about 5 particular individuals who you've got on your list to recall. The first one I have here is Andy. You let Andy know the great news. The furlough is over. Andy's being recalled. Andy is reluctant, though. because unemployment has been too lucrative. And between the state unemployment and the enhanced federal $600 a week unemployment, Andy is making close to $55,000, $60,000 a year and staying at home. The only thing that would be better would be if the Blazers were playing and he could watch some games. But so he's reluctant to return. What do you do there? I've got three observations. Number one, you can't force Andy to return to work. That said, if Andy doesn't want to return to work, an employer may need to decide to separate the employment relationship, because an employer obviously needs to have, if the decision is made, we need 8 employees now, and Andy refuses to return to work, then it may be time to end that employment relationship. Andy may be under the impression that the unemployment insurance will continue. That's not a decision that the employer makes. That's up to the Oregon Employment Department. And an employee like Andy who declines a recall offer may be determined by OED not to be eligible for unemployment benefits. I mean, an employer can tell Andy that without telling Andy that benefits definitely will not be given. It's very likely they won't be, but that's not the employer's position. So that's Andy, an employee who doesn't want to return because unemployment has been lucrative. Now let's turn to an employee named Chris. Chris has children. Let's say one's in school, one's too young and is in child care. Both school is closed, child care is closed. So Chris is in a spot. In that case, Chris would have available emergency paid sick leave for 80 hours. That could help out in that situation. Chris may also be eligible for emergency FMLA, which is another 10 weeks. And the cap on that would be $200 a day. So that would be, in that situation, the employer would not want to terminate Chris for not returning, but would want to start the clock running on these various benefits. Now, there's another employee, Joe, who doesn't have kids, but needs to care for a parent with COVID-19 symptoms. Joe may also be eligible for emergency paid sick leave for the up to 80 hours. Joe would not be eligible, though, for the emergency FMLA leave or for the temporary OFLA leave that there's been a rule granting temporary OFLA related to schools and child care. And in an employer of hard knock size, there would be no regular FEMLA or OFLA. So Joe would be limited to 80 hours of emergency paid sick leave. Pat, another employee, our fourth employee, let's say Pat is experiencing COVID symptoms. In that case, Pat may be eligible also for the emergency paid sick leave and may possibly be entitled to reasonable accommodation in the form of leave under the ADA or Oregon state law. That would require an interactive process, but it is possible. It is something that an employer would definitely want to think about. Fifth employee I have on my list is Gene. Gene returns to work, returns from the furlough, but then after returning to work, experiences symptoms consistent with COVID. In that case, Gene would be treated the same as Pat. Gene may be eligible for emergency paid sick leave of 80 hours, and there may be a need to grant leave as a form of reasonable accommodation under the ADA and or Oregon state law. So those are some scenarios or some employees who might work for Hard Knocks. I hope that they answered sort of some of the overall types of questions that might arise about returning employees.
Mike, I have a quick question.
Yes.
This is Deanna. What if an employee just says, I'm afraid, I'm fearful, and I'm afraid to come back to the workplace?
If the employee is simply afraid and it's not it's not a physical thing and it's not related to there have been instances of increased anxiety, a diagnosable condition. In that case, maybe the employee would be entitled to leave as a form of reasonable accommodation. But if it's more in the vein of the employee is cautious, for example, and likes being at home right now, wants to stay at home, that would be a situation where the employee wouldn't have any guaranteed rights, meaning wouldn't have a right to a leave, wouldn't have a right to certainly to any paid leave. The employer could do several things. I mean, the employer could respond to the situation by granting unpaid leave, or the employer might be in a situation where it really just needs to move on and replace that employee. And I think that there will be, that's a good question, because I think there will be a segment of the returning workforce who feels exactly that way, who doesn't feel comfortable. Maybe it's too early for that person. The person is cautious, reads the newspaper or online. I guess nobody reads a newspaper anymore. And just knows that there's still a risk, and we don't have a vaccine, we don't have the same kinds of treatment for COVID that we have for other things, and so the employee wants to stay safe. And I think from an employer standpoint, you can respect that, but you don't necessarily have to accommodate that. I do think that one thing employers will need to, and this is a non-legal sort of dimension, but one thing that employers will need to think about is the communities in which they operate, and whether how whatever decisions that an employer might make with respect to personnel, whether it might be perceived in the community in such a way as it has a negative impact on that employer's goodwill. So that's a non-legal consideration, but I think it's a real consideration in this environment. All right, well, I will continue then with several other questions of that nature. For example, let's say you've got an employee who has been recalled and the employee returns to work, and then you get a call in the morning, and the employee says, "I'm sick, I can't come in today." What can the employer ask in that situation? Can you ask, for detailed medical information? EEOC has said that in that case, the employer may ask whether the employee is experiencing, oops, my screen went black again there, may ask whether the employee is experiencing COVID-19 symptoms. The employer shouldn't be asking non-pandemic related, for non-pandemic related information if it is simply a matter of the employee calls in sick, because normally, or what an employer should do is to simply follow its sick leave policy. And, in most sick leave policies, we're not asking the employee for information until it's usually the third day that an employee is out. But in this circumstance, because the employee would have been in the workplace, and COVID is a pandemic and has can be very contagious, it's okay for an employer to ask that employee who calls in sick about COVID-19 symptoms. Another situation, employer wants to carefully monitor the workplace to keep the symptoms out of the workplace if possible. May the employer decide that it's going to take employee temperatures before the workday starts? And the answer is yes. Not normally. Normally that would be not allowed, but because of the pandemic and because of the risk of contagious spread, the EEOC has said, we can do that now. And that would also be true if you have an employee in a post-offer pre-employment medical exam. The temperature can be taken as a COVID precaution. EEOC correctly notes that the temperature is not the only symptom of COVID, and oftentimes persons who have COVID don't have a temperature, so it's not a it's not a miracle check, but employers can do that. What if an employee has symptoms? Can the employer send that employee home or tell the employee not to come to work? And the answer is yes, you can do that. Essentially, that is the recommendation of the CDC, the Centers for Disease Control, and a number of other health authorities, and it's based on safety. A lot of times, employers want to get medical certifications from employees before returning them to work. In the context of COVID, the question is, can you require a medical certification before allowing a particular employee to return, or can you require it for all employees before you return, such as when you're recalling them from furlough? The answer is technically yes. However, that would be it's not a very practical approach. Well, for a number of reasons. One, it's very difficult to get testing for COVID. So a doctor who does see an employee can say, this employee seems okay to me to go back to work, but will not have done a a COVID test, so you won't actually be getting that in your certification. Additionally, it's difficult to get into a doctor nowadays, unless you really do have symptoms of COVID. But it is permissible to do that. What about delaying the start date of an offeree? You've offered employment to somebody, and that offeree says, well, I've got these symptoms, and lists them off, whatever they might be. I've lost my sense of taste. I have a fever. The answer is yes. An employer in that situation may delay the start of the applicant's start date. Can it withdraw the offer altogether? Can the employer say, well, all right, you've got symptoms, thanks, but no thanks? The answer there is a little bit more complicated. It's yes, if the start date is an important issue. Meaning if I need somebody to start by the 13th and that person says I can't because I've got these symptoms, the employer can withdraw the offer. If the start date is wide open, meaning we're hiring this person, he or she can start next week, next month, we're fairly flexible, then probably as a practical matter, you wouldn't want to pull the job offer just because that employee or offeree is just having symptoms. Now here's one that I've gotten a couple of questions on over the last week. Let's assume that you have an employee who is pregnant, or an employee who fits into some immunocompromised category, such as has had cancer, or you have an employee who is age 65 or older. Can you do anything there? Either decide not to recall that particular employee from furlough because of the pregnancy or the immunocompromised health history or the age? And the answer is no. We can't, we would violate, we could violate the ADA if we do it because of, say, the immunocompromised health history. We could violate the ADEA and Oregon state law if we do it based on age. It would be gender discrimination if it's based on pregnancy. So if it's just we want to keep that person from facing the risk of being in the workplace where he or she might be exposed to COVID, well, that sounds like it's the right, the employer is trying to do the right thing in that situation, or is inclined to do the right thing, but that's not the right action to take. You'd have to have something more. There'd have to be, it would either have to be that employee has symptoms or that offeree has symptoms. Otherwise, it's his or her choice on whether to be exposed to something particularly dangerous. Got a couple of more questions here. What if the employee says, I had COVID, I've recovered from it, but I'm going to need reasonable accommodation when I return to the workplace? Is that required? And the lawyerly answer is maybe. And what I mean by that is it would certainly be a basis for engaging the employee in the interactive process to try to determine whether a reasonable accommodation is needed and is available. But if not, if there wasn't an accommodation that was reasonable, then there would be, no need to provide anything that's not a reasonable accommodation. In that type of situation, reasonable accommodations, the universe of what's reasonable as an accommodation is vast, but it might include, telework or working from home. It might include some extra personal protective equipment. It could be modified hours. There are any number of options or possibilities depending on the facts of the situation as to what might be reasonable. What if you're recalling folks from furlough? Can you ask them if they might need accommodation, reasonable accommodation on their return? The answer is yes, but it should be done in either of two ways. Number one, if you're going to ask that question, you should ask it of everybody who is returning. Or if you're going to single out a particular individual, it should be based on a unique set of facts that lead you to have that question. For example, for just sort of an over-the-top example, let's say that somebody is returning from is going to be returning from leave, and this person had his or her arm amputated as a result of complications of COVID. Well, in that case, that the person has a significant physical issue, and so that might be the basis for asking that person, even though you're not asking it of everybody, whether he or she would need an accommodation on return. Gotten a lot of questions lately about personal protective equipment, the masks, the gloves, other things of that nature. Let's try to go through a few of those. Let's say that the employer requires certain personal protective gear. Maybe let's use the example of the mask. The employer requires a mask, and you've got an employee who says, I would like to be exempted from that requirement. And it could be based on disability. It could be based on religion. It all depends. The question is, would an employer need to accommodate the employee in that circumstance? The answer is maybe. It all depends, again, on an evaluation of the circumstances. In the case of someone who is looking for relief from the rule to wear a mask based on disability, you'd be looking at what is the reason we're wearing masks? Is it necessary for workplace safety? And if so, then excusing the worker from that would likely be an undue hardship. If it's not necessarily for workplace safety, or if there are other ways to accomplish the same safety goal, then maybe through the interactive process you'll be able to identify what other options are available other than the mask. Now, in the case of an employee who says, my religion prevents me from wearing a mask, it again is the same inquiry. First, you want to be certain of what is our reason for requiring the mask. And if it's a safety basis and not wearing the mask is going to be a safety problem, then most likely allowing that employee to be exempted from the requirement would be an undue hardship. But again, we'd want to look and see whether there are other ways to accomplish the same goal other than wearing the mask. If we're granting, I'm going to move on now to the idea of paying for these things. Let's say you're granting a reasonable accommodation to an employee. Who pays for that? Almost certainly, if it's an accommodation of a disability, the employer is going to bear that cost. If the cost is too high, then the accommodation may not be reasonable. But if it's a reasonable accommodation, the employer is going to bear that cost. What about the situation, though, where we're talking about personal protective gear? If the employer requires it, then the employer is going to be paying for it. But if it's the case where the employee wants to wear it, say the employee wants to wear a mask, but it's not required by the employer, who pays there? It's probably the employee's burden at that point, but the employer should explore it to make sure that it's not needed as a form of reasonable accommodation. And the employer also needs to, and this gets into one of the topics that I did not put on the agenda, but I do want to mention. There's what's called the OSHA General Duty Clause, and that is the duty for employers under OSHA to furnish each worker employment and a place of employment which is free from recognized hazards that are causing or are likely to cause death or physical harm. So possibly paying for additional personal protective gear such as a mask might be a way to ensure that you don't run into an OSHA violation. There have been a number of OSHA complaints filed. That has been one of the spikes in activity over the past month and a half. Some things that employers should think about both on reopening and then as ongoing is cleaning the workplace, having it specially cleaned, certainly before reopening in this environment. And then many employers have adopted enhanced cleaning protocols. Those are things that would, they're both good for your safety and your employees' safety, and they're also consistent with OSHA's General Duty Clause. Additionally, not on the agenda, but it occurred to me this morning that we should talk about workers' compensation. Workers' compensation, as you know, covers work-related injuries and illnesses. So if you've got an employee who returns to work or who is newly hired, but during the period of that person's employment contracts COVID-19, that person may file a workers' comp claim. Proof, of course, is as with any workers' comp claim, proof that it's work-related is the key, and it may be difficult for the employee to establish that he or she contracted COVID-19 in or through the workplace. But the cleaning the workplace before reopening and adopting enhanced cleaning maintenance procedures are ways to help eliminate the possibility that a positive COVID diagnosis would not be determined to be a workers' comp covered condition.
Mike, I'm going to stop
At this
you for
point,
just a second and just
yeah.
see. We've got about 15 minutes left, and I mean, this is fabulous information. I just want to see if there's anybody that has a question. I can't see the chat, so if you put anything in the chat, just go ahead and unmute yourself and ask the question. No questions. So you've scared the heck out of them all, Mike.
Right. Well, I was going to ask at this point anyway if there are some questions or scenarios. If anyone has a scenario of concern, maybe we could talk about it.
So I would just ask in terms of, you know, I know I've had businesses that have talked about liability, right? Either with customers or with employees. Where do you see that going in terms of holding employers liable for someone contracting COVID-19? So beyond just sort of workplace OSHA violations, but like real, true litigation.
Well, if it's an employee, I would think that it would be workers' comp preempted. But if it's, you know, so using this imaginary company Hard Knocks, if one of these employees who is returned from furlough contracts COVID and wants to claim that it's through the workplace, I think that, you know, any litigation that employee might want to bring, you know, charging negligence or something else, is probably going to be workers' comp preempted. There's certainly the potential for OSHA violations, that kind of thing. Now, if it's a customer to a store, let's say Hard Knocks opens, employees return, and a customer who shops at Hard Knocks later contracts COVID and then finds out that the employee Chad at Hard Knocks also had COVID. There definitely is a possibility there that the customer would sue the store and say that you were negligent in the way you either with cleanliness of your store or in your precautions with respect to employees. I don't know if if the customer would be able to prove that claim, but it certainly would be something that would be messy in terms of litigation mess and expense. And other than, to be honest though, other than being vigilant about the workforce and being vigilant about keeping the workplace clean, there isn't a whole lot that an employer can do to avoid that kind of a situation. You know, because there have been a lot of, you know, positive tests, and in many cases, the source of you know, the illness isn't known, and so proving it for the claimant is going to be tough. But there could definitely be a fair amount of litigation related to COVID.
Mike, I have a question. If
sure.
You know, we've been reading stories about certain parts of the country, and I've even been where store workers have been sort of verbally harassed or what have you for asking asking customers to wear masks. Of course, there was that security guard, I forget what city it was in. But generally speaking, does an employer have an obligation to provide physical security in their environment, or is that totally based upon whether or not there's a perceived threat, such as protests or outright threats or what have you?
It's a very good question. I do think, it's a question I've never thought about, and I will look into it and perhaps email you some further thoughts. But I think that an employer has a general obligation under, for example, under the OSHA General Duty Clause to provide a relatively safe workplace. There are certain things, such as that security guard it was in Michigan, and I don't know if that was an armed security guard or if it was just if it was unarmed security. But I don't think that the store in that case would have anticipated that a customer told to wear a mask and sent away would then return 20 minutes later with a group of 3 people and shoot the security guard. So I don't think, I guess what I'm saying is I don't think an employer would be held to anticipate the need for that kind of security, that level of security. But I do think both in the COVID context and outside of the COVID context, that an employer should be thinking about the security of its workplace. Employers frequently think about it for the security of anything of value in a workplace, whether it's money or products. But they should also be thinking about security for their employees, and should be taking steps designed, reasonably designed steps to meet foreseeable security needs.
Thank you. It's a weird, it's just an odd time when so many people, regardless of your politics, are equating health care decisions with infringing on civic freedoms, and tempers are short. I mean, I've known people who are working at the Costco nearby who are getting yelled at by people because they're being asked to wear a mask. Now, they're in the right to require that, but the tensions and the reality of that on the ground is really startling for a lot of people.
I agree with that. It definitely is. Reading some of the stories about things that are taking place in other parts of the country is fairly eye-opening. But that also is something that employers should be paying attention to, is what is the, to the extent that it's discernible, what is the sort of the tension level in the community in which I operate, and does that warrant taking any additional steps beyond what I'm already taking.
Mike, I have a question about employees that are on furlough or just on furlough, and they've been on furlough and they're receiving unemployment benefits, and as you aptly termed it, enhanced unemployment benefits. And you want to start bringing your team back, but you want to do that in maybe and bring an employee back part-time and start out with 20 hours a week. And the employee's like, I'm all set with my unemployment, and this is not 20 hours a week is going to mess up that unemployment compensation. Are you back to the same conversation around, it's a you don't have a choice, and I mean, you can't force them to come back to work, but then you look at whether or not you need to go with a separation because, but I do think the unemployment insurance with the additional $600 a week has caused employees, especially hourly rate employees, to really question whether or not it's better just to ride it out till the end of the 26 weeks and see what the workforce looks like.
Well, that I've actually dealt with the very question you're talking about here, where an employer wanted to bring an employee back half-time, and the employee was reluctant for that reason. I guess I have a couple of thoughts. Number one, if the employee was working full-time before and is now being invited to come back part-time, that employee may still qualify for some, partial unemployment benefits. Again, the employer doesn't control that. That's up to OED. And, the employer can tell, pardon me, the employer can, be transparent and, tell the employee, I can't tell you whether you'll still get unemployment benefits or not. You might, and there is language in, some of the Q&As that suggests at some point the employee will no longer qualify, depending on the number of hours, the amount of work loss that the employee is experiencing. But from the employer standpoint, in that situation, the employer can understand that the employee's situation, why the employee is wanting to remain in unemployment because it's more lucrative. But I think you're right. The employer would really be back to deciding, all right, do I need to move on from this employee? Do I need to have somebody back? And if so, that's a real business need that has to be addressed. And if the employee is, unwilling to return to work, folks quit all the time, and I'd probably construe that as a voluntary resignation, and wish the employee well.
Excellent. Thank you, Mike. We've got about 1 minute left, I think. I just want to have 2 minutes left. Thank you very much. This has been really, really valuable information. Answered, I'm sure, a lot of questions that employers are facing. Anybody with the last question? All right. So
and if you think of anything afterwards that you want to ask, feel free to send me an email, and I'll be happy to respond.
Thank you, Mike. That's very generous of you. So
Sure.
Thank you. Really appreciate your time today. This is the Small Business Solutions Series workshops, and we have 3 scheduled next week. On Tuesday, it's a little difference in time, so we're starting at 10:45 to accommodate Representative Susan McClain, who will be holding a small business roundtable. So it's a really good time to talk to your legislators. And then on Wednesday, we have how to, I guess I would call it best practices for bringing employees back safely from an essential business. So this is an employer that's been in business and been up and running and has some great ideas for you to engage and communicate with your employees, and also just, again, sort of set some safety guidelines around. And then on Thursday, we have David Jensen, who will be talking about entrepreneurial structures and organizational structures. So a great lineup. Hope you can join us. And thank you very much for joining us today. Take care.